This is a Business AM. My name is Simba Elijah Charles Kiage. You are watching your economic review this morning, where we are opening you up to the biggest economic headlines that you're waking up to this morning. Now let's begin in the corridors of justice, where Chief Justice David Maraga has called on the president to dissolve parliament. This following what the CJ has said is Parliament's failure to enact laws to achieve the two-thirds gender rule. In his address to the president, CS Maraga says, despite 6 petitions for over 9 years and 4 court orders, Parliament has refused to enact the requisite legislation. While the CJ admits that dissolving Parliament will have huge economic ramifications, especially amid the COVID-19 pandemic, the CJ says there will be no gain without pain, adding that we must hold everyone accountable for their actions or omissions. Now, whether the president will heed the CJ's advisory to dissolve Parliament now remains to be seen. First question, does the president have the power to dissolve Parliament? Yes, he does, but is he going to do it? What would the process of dissolving Parliament involve? And at this point, I want to bring in Tommy Randall this morning. Tommy, let's attack this question this morning. Well, the call is out there now. What do you expect is going to be the immediate reaction for the president?
I honestly don't see him dissolving the parliament. They will probably have some kind of negotiation to see if they can solve this problem. But in implementing this is not something needs to be done and be done. There are provisions to give the parliament time and to extend, give them more time to be able to implement it, which they have not come to. So this is the worst case scenario that we have been forced to approach because parliament has not acted.
All right, Tommy, but I want to take you back and say, well, people are looking at it from 2 perspectives this morning as we try to understand where the CJ is coming from. Well, does the president have a leeway? Because even right now, there have been court orders as well that have been directed to the same effect. Does he have a leeway to say, I might not, I might? Because even as we say negotiation, but how does he negotiate within a court order?
The way the Constitution worded, it uses the word shall dissolve the parliament after he receives the message from the Chief Justice. So technically, according to the Constitution, if he was to follow the letter of the law and the spirit of the law, he should dissolve the parliament. Now, what will happen, we don't know. We have to just wait and see.
All right, I don't know whether OROGO you can get me this morning, Daniel, because I want to bring you in as well so we can deliberate on this issue. I mean, what choices now does the president have? And Daniel, if you may, how did we get here? Quite unfortunate that we actually can't get there. Tommy, I want to also pose the same question to you this morning. Can you briefly, if you may, tell anybody wondering what is going on, how we actually did get here, where the CJ and the president find themselves in this morning?
When we promulgated our constitution, we got a broad plan of what we needed our country to attain. And that constitution gave parliament a certain number of years to actually write law specific to certain things. So in regards to representation, the 2/3 gender rule requires that not more than 2 gender represent people in parliament. Now, parliament has tried to pass several laws but none of them have probably even gone beyond the second reading. And also, the Constitution gives any Kenyan citizen the authority to challenge the constitutionality of Parliament based on the fact that they do not fit the two gender rule. So several people have gone to court to challenge the constitutionality of Parliament, the way it's constituted, and orders have been given sent back to Parliament to really enact those laws. But like I said, you cannot force Parliament to enact any law. There's a Constitution of Kenya Amendment Bill 2015 that addresses that, and I'm sure there are 3 others that I'm not too familiar with the details with, but it has been tried. Parliament just never comes to agreement. You've seen incidences where when time for debate comes to debate 2 gender rule, there's no quorum, people don't show up. So now, after all that, also when High Court made its ruling, those notices were sent to the executive, to the AG's office. The AG hasn't really done much to get anything done. So this puts Maraga in a very tough situation. And I'm sure people are going to politicize this based on the past and the future. But remember, implementing the constitution is not optional. It's something that needs to be done. This can has been kicked down the road for too long. That's how we've gotten here.
All right, George, I wanted to rope you in on this as well. George, I mean, from where you're sitting, now people are calling it a bombshell. Do you consider it a bombshell?
I don't think it is a bombshell, Elijah. Remember, we enacted our 2010 Constitution, and under Article 27, Sub-Article 8 in the Bill of Rights, it states that the state shall take legislative and other measures to implement the principle that not more than 2/3 of the members of an elective or appointive bodies shall be of the same gender. I think that is very clear. The government has been taking us around in circles that this is not implementable. But that article talks about legislative and appointive positions. So even if we could not achieve that on the legislative side, we could have achieved that on the appointed position. For example, the president has the prerogative to appoint cabinet secretaries. He has seen this being achieved in this part that the president has powers to do. And then Maraga drew his advisory opinion still from the same constitution, that is under Article 261 Sub-Article 7, that states that if Parliament fails to enact legislation in accordance with Clause 6, the Chief Justice shall advise the President to dissolve Parliament, and the President shall dissolve Parliament under Article. Has thrown the gauntlet out there for the President to act. I am very sure that probably, or I'm sure that might not dissolve Parliament. But I think this is a warning shot to the executive and the legislator and the legislative arm of government that this is something that they have to deal with. They cannot keep on procrastinating on this forever.
Yes, George, if I may jump in on that just before I let you go. Now, this is what some, I would say, constitutional minds are throwing outside there, even as we go to the clauses and sub-clauses that talk about the position that we find ourselves in. Now, listen to this. While the other two-thirds gender principle is a constitutional requirement that must be met, in fact, it's a requirement under the Bill of Rights in Chapter 4 of the 2010 Government of Kenya Constitution. The fifth schedule that guides the consequential legislation in Article 261 does include, all right, Article 27 and 81 as part of the specified legislations to be enacted by Parliament within a specific period. Therefore, in their view, they are saying that the constitutional principle of the two-thirds gender remains a state affair, not necessarily as contemplated in Article 27, 6, and not just a Parliament affair alone. Do we have, therefore, a leeway for the president to wallow and say, well, it's not clear, I'm not confined by a period?
I think Elijah, my take is that the two-thirds across both the legislative, the judiciary, and the legislative arm of government. And I think the paradox is that even the judiciary itself has not been able to achieve the two-thirds in the rule. That's the paradox. So even Maraga, as he pronounces himself on this, should have had an introspect into his own department. Has he been able to achieve the two-thirds gender rule as envisaged in Article 27 of our Constitution? And therefore, I think it is easier to throw this to the executive, but all the arms of government, as it were, must come out clean and tell us what is the roadmap towards achieving the two-thirds general rule. If it is not possible, then we need to go back to the electorate or to the populace and say that this is not possible, this is the way we should take. But otherwise, there's no two way about the constitution. I think Tommy put it very well. Once something is in the constitution, you must implement it. If you cannot implement it, then the only way it is to review that part of the constitution that you're not able to implement. So I think even as Maraga pronounces himself, he should also look inwards and check what has the judiciary done in terms of its appointments to achieve the two-thirds general rule. Elijah.
Fantastic.
Tommy,
Tommy, just 2 minutes. Tommy, just 2 minutes as we clear this conversation and go for that tiny break before we come back and continue with other issues this morning. Tommy, so what next? I mean, yes, the president has not spoken. Are we expecting to speak? And from what perspective do you expect him to pronounce himself?
I think if I was in his shoes, the way I would approach this is that I would sit down with the Speaker of the Senate and the Speaker of the National Assembly and see if anything can be hashed out through Parliament quickly to avoid having to dissolve the Parliament. So I would expect to address the nation after consultations with them and his advisors. Whether that will happen, only time will tell.
Pretty much, gentlemen, I beg we go for this tiny little break. Once we come back, we'll be looking at issues that are also right now, because we do know the Ministry of Education and TSC have plans to get the 2020 school calendar underway. But is that possible? Because we do know that some members of the economy have already moved to court to challenge that decision. And once we come back, it's KRA and also our debt situation in the country shortly after this.